Good evening, ladies and gentlemen. How is everyone doing this evening? Welcome back to the infamous channel where we do reenactment of the Sean P. Diddy Puffy Cone reenactment of his pretrial sentences. Today we're gonna do the bond reconsideration for the bond, and we're gonna have a couple of different voices, well, actors. Well, so three of us. We missing one, and hopefully our others will come. But I didn't want to keep you guys from too long because this is a 68 page reading. So without further ado, we have Miss Johnson, and then I don't know why Mimi changed her name, but I don't know who she is now. Okay, let me she's Agarella, right? That's who you are now. Let's see. Hold on, let me just change her name to the name that she's supposed to be. Hold on a second, y'all. We'll get it together one day, y'all. Hey, Mr. Angelifio, or whatever, how to say your name. I don't know your name, sir. Hey, Mimi. Hey, Miss Young.
Hey,
All right, guys, without further ado, let's get started in our reading of the transcript. Let me go ahead on and put this up so we can get started. All right, everybody. Ready? Roll 'em. Criminal cause for bail appeal hearing in case number 24 CR 542 United States versus Sean Cone. Counsel, please state your appearance for the government.
Good afternoon, Your Honor. Emily Johnson, Madison Smizer, Christy Slavic, Mitzi Steiner, and Meredith Foster for the government. Behind us from pretrial services are officers Francesca Tessier, and Joshua Rothman.
And for the defendant?
yes, good afternoon, Your Honor. Mark Agnifilio with Terry Garregos and Mr. Sean Love Combs is with us today as well.
Okay. All right. Good afternoon. I've seen the submissions and I reviewed the previous submission that the parties made it to Magistrate Judge Tanner Falsky. I've looked at this transcript for the bail hearing yesterday. Let me just share with you my initial thoughts to help counsel prepare cabinet your comments appropriately. The government primarily seek detention based on risk of flight and the danger of obstruction of justice or witness tampering. Regarding those two bases, first, my lesser concern here is risk of flight. Although that is a concern, certainly Mr. Cone is a risk of flight. Defense counsel has submitted evidence regarding the efforts that he and his client had made to try to show the court that the government that he is not a risk of flight. The government has again attempted to prove that he is a risk of flight. The government has to do more than just simply prove he's a risk of flight. They must prove that he is a risk of flight and such that no condition or combination of condition will reasonably assure his return to court. The package that is being submitted by Mr. Cone, I think, does that give the court a reasonable assurance that he would return to court? regarding the issues of whether or not the government has proven risk such that no condition or combination of condition that would reasonably assure that his return to to court remains in a bit an open question in my mind. But certainly, the package that seems submitted is not sufficient to reasonably assure that his return to court given his wealth. The bigger concern deals with the danger of obstruction of justice and the danger of witness tampering. This is a real concern that I have here. I've seen the party's submission, but I just want to give counsel my thoughts as to what I primarily concern about. Having said that, I'll now hear from the parties, starting with the government, since the government has the ultimate burden here.
Thank you, Your Honor. Would it be acceptable if I spoke from the lectern?
You can speak from the lectern. You can stand there. You can sit there. Whatever you are comfortable is fine with me.
Thank you, Judge. Your Honor, this case is about Sean Combs' physical and sexual violence against women and others. This physical and sexual violence has gone on for decades. It's also about the vast efforts he undertook, using his extensive resources to cover up his crimes. In other words, the very conduct he's charged with shows his dangerousness, his resources, and his willingness to lie and obstruct. Yesterday, Judge Chernovsky recognized this when she found that there were no conditions or combination of conditions that could assure the safety of the community or the defendant's appearance in court, and she detained the defendant. The government respectfully submits that Your Honor should reach the same conclusion today. As the court just said, you have, obviously, read our papers in detail and the transcript from yesterday. I want to be clear that we are seeking detention on, in addition to risk of flight and risk of obstruction of justice, but also just on dangerousness generally. All of those factors to be considered in ordering detention weigh in our favor here. As I know the court knows, in this case, detention is presumed under the Bail Reform Act because the defendant is charged with sex trafficking, which is an offense under Chapter 77 of Title 18. It's the defendant's burden to rebut that presumption, and the magistrate court already found that he did not do so. So I want to start with dangerousness and obstruction. And I'd like to talk about the seriousness of the offense first, which reflects both the defendant's dangerousness and the risk of obstruction if released. Many of the facts are set forth in our submission and were on the record yesterday. So I only want to briefly review a few with Your Honor before I dive in. The defendant used force, threats of force, and coercion to cause female victims to engage in sexual activity with male commercial sex workers that he referred to as freak-offs. These were elaborate sexual performances that he arranged, directed, masturbated during, and often electronically recorded. These began in and around 2009, at least, and lasted until at least this year and often took place over multiple days and frequently with more than one escort. These freak-offs were arranged with the assistance of members of his enterprise who set up the rooms, stocked the rooms with supplies, arranged the travel, delivered the cash to pay the escorts, among other tasks. The defendant used narcotics so that female victims could continue to participate in freak-offs despite exhaustion and fatigue that they began to experience, as these were sometimes multi-day events. These narcotics included ketamine, ecstasy, GHB, and others. And victims themselves, in communications that the government has seized, describes themselves as being drugged during these freak-offs. I mentioned that the defendant electronically recorded the freak-offs, and he did that at least in part so he could keep the recordings and use them as blackmail against his victims. So I want to pause on that for a moment. In addition to witnesses who will testify to this fact, it's also in black and white in communications that the government has seized. For example, in December of 2015, a victim texted the defendant and makes explicit reference to this type of extortion. This is the quote. "You know what sick and disgusting shit I was reminded of the other day? You forcing me to do something else, which I'm not going to mention on the public record, or you were going to leak some FO shit." FO standing for freak off. The defendant recorded these women engaged in freak-offs. He threatened them with those very videos to get them to engage in even more. And the defendant makes a lot of claims yesterday in his papers about the victim's motives and speaking up now, but that message is from 9 years ago. And I suspect that we'll hear that we should ignore these types of things because they're old. But this isn't the only time there's communication that explicitly references this kind of blackmail. In fact, the same thing happened much more recently, several years later, after 2015, when a different victim said, and here's a quote, "He just threatened me about my sex tapes that he has of me on 2 phones. He said he will expose me. Mind you, these sex tapes where I am heavily drugged and doing things he asked of me for the past 3 years." That's just 2 examples of the defendant's egregious conduct in extorting and blackmailing victims that happened years apart. And so it's rich when the defense submission filed today accuses the victim of extorting the defendant. Let me be clear. The only person who is engaged in extortion in this case repeatedly is the defendant. At least a dozen witnesses will confirm that they personally observed the defendant's violence towards women or the injuries that were sustained as a result. And in addition to that physical violence towards women, there's also evidence of other violent acts, including physical assaults on other individuals, including employees and witnesses to violence, kidnapping, and arson. The defendant surrounded himself with and used firearms, including 3 defaced AR-15s and a high-capacity magazine loaded with 59 rounds of ammunition that was seized from his LA and Miami residence this year. Yesterday, defense counsel argued that these were the same guns used by the defendant's professional security team. But what he hadn't told the court yet was that we did seize the guns used by his professional security team. We took 6 of them. They were licensed guns that were registered to the security team. They were stored in the defendant's home and he had access to them. But for obvious reasons, we're much more concerned about the defaced firearms hidden in his personal closet, and that was our focus. But it's worth noting that the defaced guns have nothing to do with security and have everything to do with dangerousness. And even beyond that, when we consider the additional guns that his security team has, he has even greater access to firearms. One more point on this is that the security team is now the same team that he suggests be allowed to monitor him while he's on bail. His head of security was served yesterday with a search warrant for his devices because of what our investigation has revealed about his own personal involvement in the offense, conduct, and in offenses under investigation by the government. As the court knows from the transcript of yesterday's proceeding, I spoke then about an incident that occurred on March 5th, 2016 at the Intercontinental Hotel in Los Angeles. And yesterday, the government attached publicly released surveillance footage to our submission as an exhibit. And as I said yesterday, this is a critical incident to assessing both danger and obstruction. I'm going to talk about it a little bit more today with some additional detail. Contrary to defense counsel's argument yesterday, which attempted to inaccurately recast this incident as just a fight in a relationship, the events of March 5th, 2016 are powerful evidence of trafficking, a recorded example of defendant's use of force in connection with the freak-off. So I'm going to summarize the evidence again with some additional details that I did not mention yesterday. In short, the evidence shows that the defendant had a freak-off at the Intercontinental Hotel in Los Angeles on March 5th, 2016. The defendant contends that this incident only involves the defendant and the victim, but this is wrong. We have multiple sources of evidence that demonstrate there was at least one commercial sex worker who was with the defendant and the victim in the hotel room prior to the assault that's recorded on camera and remained in the room while the assault was being captured. Following the freak-off, the defendant violently assaulted a victim who was sneaking out of the room to leave the hotel. You can see in the hallway surveillance video that she isn't even wearing shoes, that she is leaving. She's leaving as fast as she can because she's trying to get out of there. She's in danger. In the video, the defendant storms out of the room in nothing but a towel. He comes up to her. He punches her. He throws her to the ground. He kicks her. He attempts to drag her back to the hotel room, and then he throws a vase at her. Text messages in the hours and days that follow confirm the injuries caused by the incident. These are quotes. I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. This is clear evidence of the dangerousness of the defendant, and it's evidence that he has to try to minimize it. He cast it as a misdemeanor assault arising out of a lover's quarrel based on the fact that he wanted to get his clothes back. But that's not what happened here. The evidence shows that the victim tried to escape the hotel room where the defendant and an escort were without even putting on her shoes. The defendant then violently beat her and tried to drag her back to the hotel room. It was only when hotel security staff intervened that the victim was able to leave the hotel. So this is just one example of violence being used in connection with the freak-off. But this incident is also important because of everything that happened after the assaults, because that's when the cover-up started. First, the defendant tried to bribe a hotel security officer with a handful of cash in exchange for that officer's silence. The security guard refused to be bought. Then the defendant's staff got involved, contacting hotel security to get the footage of the incident and keep it from being seen by anyone. And by March 8th, 3 days later, the surveillance video somehow disappeared from the hotel server. The defense has argued that there was no criminal investigation, so there couldn't have possibly been obstruction, and the defendant was just trying to prevent something embarrassing from becoming public. But that's not what the evidence shows. In fact, what the defendant himself was saying immediately after the assault on March 5th, here's a few messages he sent right after the timestamp on the surveillance video recording. Call me. The cops are here. I got 6 kids. Yo, please call me. I'm surrounded. You gonna abandon me all alone? While we don't have evidence that the police were actually there, the point is that the defendant knew he had done something that could elicit a law enforcement response, and he had to cover it up. And critically, his staff knew that police had responded to the victim's apartment. They have photographs of the responding officer's Los Angeles Police Department business card and their text messages. And those staff members remained in contact with the victim to ensure that she would not talk to the police. So these communications, the video disappearing, none of this is a coincidence. It's a result of defendant's employees trying to cover up his crimes, all at his direction. And the cover-up continued until last year, after the civil suit was filed in November that, among other allegations, detailed this assault at the Intercontinental. The defendant responded, and I quote, "I did not do any of the awful things alleged." There is no other way to read this but as an unequivocal denial of his participation in this incident. It's also yet another way that he continued obstructing and covering up what he did. In this year, after CNN released the surveillance video, the defendant ultimately admitted that he was actually the person on that video, but only after it was leaked to the media and only after there was indisputable proof of his identity on tape and his violence on tape. But yesterday, we got more to the story. That apparently this assault was precipitated by the defendant being hit in the head while he was sleeping, by a cell phone, and his clothes being taken in a small overnight bag that you can see the victim walking down the hall with, in addition to her purse. This is apparently why he runs out of the hotel in nothing but a towel. But our evidence will show that's just not what happened. Assuming, for the sake of argument, that it did, which it didn't, but assuming that punching, kicking, and dragging someone in and of itself is a crime, and covering that up is an act of obstruction. And if it's about the clothes and wanting to get the clothes back, which again it's not, why drag the victim back down the hall to the room? And you can see that on tape. That's what he does. This explanation is just another cover-up. It's just more lies, and it's just more obstruction. This sequence of events and all the indisputable evidence, from the videos to the text messages to the photographs during communications, makes clear that you cannot take the defendant at his word when he denies his criminal conduct. But make no mistake, March 5th, 2016 is far from the defendant's lone act of violence and obstruction. So let's talk a little bit more about that. Freak-off activity is the core of this case, and freak-offs are inherently dangerous. They use force, coercion, and drugs to coerce the victims into doing the freak-offs. The defendant control aspects of their lives, use significant physical force against them, and all to compel them to engage in these lengthy sex acts. Yesterday, the defense said they interviewed about half a dozen escorts who would dispute the government's account of what happened during the freak-offs. Our investigation is ongoing, and so I can't say too much about this, but I will note that half a dozen escorts is just the tip of the iceberg of the number of escorts who have participated in these freak-offs. And yesterday, the defense also spent a lot of time talking about how these freak-offs were between consenting adults and how the government was not claiming sex without consent. Abuse occurred in the context of at least one long-term relationship, which we acknowledge, but the government's theory does involve a lack of consent. This case is charged, at least in part, in count 2 as sex trafficking by force, fraud, and coercion. When a woman is being beaten and coerced in order to get her to engage in commercial sex activity, those sex acts are not consensual. And as I said yesterday, it is really important to note that long-term relationships and abusive relationships are not mutually exclusive. The government expects to introduce the testimony of expert witnesses regarding the dynamics that appear in almost all sex trafficking and sex abuse cases. Similar testimony has been introduced in several cases in this district. A few examples are United States versus Haddon, United States versus Ray, United States versus Maxwell, and United States versus Rivera. We expect that these expert witnesses will explain issues of apparent consent and how abusers control their victims, even in the context of long-term relationships in which the victims express love for their abusers and continue to go back to them. We further expect that these expert witnesses will discuss various forms of coercion, including isolation, intimidation, violence, manipulation, surveillance, narcotics, grooming behaviors, and others, and generally why victims do not leave their abusers and immediately report their crimes. The focus of today's proceeding however, is not and should not be on the dynamics of abusive relationships. Today's proceeding is squarely focused on the defendant alone and whether the defendant presents a danger to the community, whether the defendant threatens the integrity of these proceedings, and whether the defendant presents a risk of flight, all of which he does. Defense counsel has made much yesterday and today in his letter about his misinformed view that there was not a sex crime here, and therefore the nature of this offense doesn't weigh in favor of detention. He's argued, in essence, that anyone who was participating in a freak-off wanted to be there. That flies in the face of the evidence in this case, much of which we've laid out to the court, but it also shows a misunderstanding of the law. When participants in commercial sex activity are threatened with the release of collateral videos like those 2 messages I read, when they are threatened with the loss of their livelihood and housing, we'll get to that in a minute, and when they're beaten both during and outside freak-offs, you saw a video of that, they cannot consent. That is trafficking. This view was especially evident when counsel spent time minimizing and horrifically understating the defendant's violence. The video from March 5th, 2016 is far more than a misdemeanor assault, as he claims. When force or coercion is used in connection with commercial sex, as it is here, again, that's trafficking. The defendant's decades-long history of violent conduct makes clear that even the most stringent bail conditions will not suffice to ensure the safety of the community. The inquiry in this context is focused on the danger to any real person, and the evidence shows that there is a risk of physical danger towards victims, employees, and other individuals. The investigation has revealed evidence of numerous assaults against female victims and other individuals. These assaults involve choking, hitting, kicking, dragging victims, sometimes by the hair. They sometimes occurred in cars where victims' heads were slammed against the car window or on the floor of a car. And again, independent evidence like text messages confirms this type of violence. Without attributing any of these messages, I'm going to read 4 that make my point. I turn my head for a second and you get fucked up and you drag me down the hall by my hair. I have bleeding cuts. You hit me in the head 2 good times. When you get fucked up the wrong way, you always want to show me that you have the power and you knock me around. I'm not a rag doll. I'm someone's child. And we don't just have the text. We also have witnesses who can confirm because they witnessed this violence and they witnessed the injuries. And this conduct took place behind closed doors, in houses, in hotel rooms, in cars, in settings that are not easily monitored by even the most stringent conditions of release. And I know that Judge Tarnowski was particularly concerned about this point and also about the next one, that the defendant's violence was premeditated and spontaneous. And I think the text messages I just read highlight that. And the defendant's violence, the spontaneity, excavate the difficulty of crafting conditions of release to ensure the safety of any person. How do you craft bail conditions that can address the defendant's tendency to become violent at the slightest provocation and to become violent, as the text messages say, when he gets fucked up the wrong way? In fact, Judge Tarnowski found that she did not believe defense counsel had the ability to control the defendant given his substance abuse and anger issues. There is a long-standing pattern of abuse here, a pattern that has been entirely undeterred by threat of public exposure or law enforcement intervention, and is probative of whether the defendant will continue to engage in that pattern. I know we cite this case in our papers, But the Mercedes case in the Second Circuit, 254 F3D 433, Second Circuit 2001, talks about the danger of releasing defendants with a history of domestic violence, noting that a domestic violence history is probative of a dangerousness determination because a willingness to strike a loved one is evidence of a tendency to be violent and dangerous towards others. And in that case, the circuit reversed the district court's order of release for a defendant with a history of domestic violence but no criminal history. So let's turn to obstruction now. And I know that Your Honor is particularly interested in that point, in this point. So the risk of obstruction in this case is heightened because of the defendant's power. It gives him a unique ability to influence people and to intimidate witnesses and victims. Witnesses have universally, one for one, expressed to us their extreme fear of the defendant. Extreme. His influence makes it so difficult to convince witnesses to share their experiences and to trust that the government can keep them safe from him. I talked about some of it before with the March 5th incident, but we have evidence that further indicates that the defendant and his co-conspirators will deflect, minimize, and lie about his conduct. Defense counsel spent time trying to recast his, what I submit to the court are obvious, obstructive efforts as just maintaining contact with people. So before we dive in, I want to be clear about a few principles of obstruction based on the statutes that have been charged in this case. There needs to be an existing investigation or official proceeding, and the defendant need not know about it. What we will also show that the defendant knew about this investigation at least as of January 2024, and he certainly suspected the possibility of an investigation after November of 2023 when civil lawsuits were filed alleging, among other offenses, sex trafficking. So following that November lawsuit, when the defendant certainly had reason to suspect the possibility of an investigation, he and his co-conspirators continued their efforts to reach out to potential victims or witnesses. This outreach has included directly contacting at least one victim in November of 2023, constant contact with witnesses to the charged conduct, and with contacting of witnesses, including those who received grand jury subpoenas prior to the dates of testimony or government meetings. And this contact is as recent as July of 2024, so well after the government has definitive proof that the defendant knew about this investigation. So two of those examples are there were communications between the defendant and a witness who received the grand jury subpoena. These communications are both prior to and following the witness meeting with the government, and the government has evidence that the defendant knew that this witness had received a grand jury subpoena. And both before the meeting with the government and after the meeting with the government, there were 14 total contacts between the two of those people. In another case, a witness was served with a grand jury.
Hold on a second. Go back for a second. You said there are 13 contacts between two of those people? You mean two witnesses or just between the defendant and the witness?
I'm sorry for not being precise, Your Honor. There were 14 total contacts between the defendant and the witness.
Okay.
And my second example, a witness was served with a grand jury subpoena in June of 2024. Thereafter, was contacted multiple times by the defendant by phone and text in June and July of 2024, despite the fact that the two had not spoken in several years. They were suddenly back in contact leading up to the defendant's, in the aftermath of the witness receiving a grand jury subpoena. And these efforts by the defendant were also crafted to avoid detection. He used intermediaries to reach out to people. And in an instance I describe in detail, he recorded conversations with a victim on the device of a co-conspirator. These kind of efforts, these kinds of means make obstruction even more difficult to detect when it's being done through other people and on other devices. We know from the evidence we've collected that the purpose of these calls was to spread false narratives. So here's an example. The instance that I mentioned where the defendant directly contacted a victim in November 2023, he placed 2 calls to the victim, both of which are recorded on the co-conspirator's phone. And as background that will help explain some of the things that are discussed in the call, the defendant provides financial support to this person. So early on, November 19th, which is 3 days after the filing of the civil lawsuit by another victim, the defendant received a text from this other person in response. It reads, "I feel like I'm reading my own sexual trauma. It makes me sick how 3 solid pages, word for word, is exactly my experience and my anguish." The defendant then called the victim twice. Those are the recordings. And in those recordings, he gaslit her and he attempted to convince her that she had willingly engaged in sex acts with him, but she pushed back. She told him she felt manipulated and clarified that what his description of events was not how she saw things. Throughout these recorded calls, the defendant repeatedly talks about how he was not supposed to be speaking on the phone and not supposed to be using the phone, and he instructs the victim not to text him. These statements clearly shows his state of mind. They show that he was on notice that there could be an investigation into the claims raised in the lawsuit that had been filed 3 days earlier. And at the end of the second call, the defendant assured the victim that if she continued to support him, she ain't got anything to worry about, which is a thinly veiled reference to his continuing his financial support. And subsequent text messages makes explicitly clear that that's what he was talking about, because 2 days later, he texted a co-conspirator in reference to the financial support that he provides to this victim and said, "Make sure that," and he uses a name here, the name is in an individual who is his financial advisor, is not doing anything dumb, like not having that rent paid on time. The defendant made sure that financial coercion continued, clearly, to keep the victim close and in his control. The defendant's long history of obstruction and violence demonstrates that he simply cannot overcome the presumption that no condition or combination of conditions can ensure the safety of the community or the integrity of this proceeding. Courts have denied bail in similar situations. We've cited some cases in our letter. Of particular interest, I think it's United States versus LaFontaine. And this is a slightly different posture because it's a revocation. But the facts of that case are that the defendant contacted a potential witness and attempted to feed that witness a false narrative with the hopes that the witness will adopt it as that person's testimony. And that's exactly what's going on here. And the government's request for detention is consistent with other cases of this kind in this district and in this circuit. These cases stand for the proposition that sex trafficking defendants, regardless of their age of their victims, are routinely detained pre-trial, particularly when they have engaged in repeated obstruction. I went over some of these cases yesterday. I'll touch on them lightly again.
No, that's not necessary. I'm familiar with those cases.
Okay.
No, but let me ask you this. In the records, the government has previously indicated that there was another potential witness that the defendant contacted between September 10th and September 14th, some 58 times. Can you give me a little further elucidation on that?
Oh, sure. So that requires a little explanation of a recent civil suit. So on September 10th, so last week, an individual named Dawn Richard filed a civil suit against the defendant and other individuals and entities. Ms. Richard was formerly in a band with the defendant and a third individual named Kalina Parker. The allegation in Ms. Richards' lawsuit focused on some of the time period of the charged conspiracy. They focused on particular events starting in 2009 and for some time period thereafter. Among other things, Ms. Richard alleges witnessing violence by the defendant towards a victim, including assaults and the like. So their lawsuit was filed on September 10th. On September 13th, the other member of the band, Ms. Harper, released a statement where she, in sum and substance, sort of says what Ms. Richards' experience wasn't what I experienced. But between those two dates, between September 10th and September 14th, the defendant and Ms. Harper had 128 total phone contacts. He called or texted Ms. Harper 58 separate times in 4 days. There has been no contact since September 14th. Granted, that's only been a few days. But I think what's highlighted about that incident is that it makes clear that the defendant has an ongoing ability to keep witnesses, even witnesses to very distant abuse and very distant things, in his pocket and at his disposal. One other, Your Honor. We had discussed some cases yesterday. We didn't discuss Lawrence Ray, which I think is another case that does support our argument here. I don't think we've touched on that, so I'll just briefly.
The case dealing with the official proceeding requirement.
No, Lawrence Ray is a racketeering and sex trafficking case in this district, and Magistrate Judge Fox ordered detention based on risk of flight and dangerousness. And I think one thing that's similar about the Lawrence Ray case to this case is that in the bail argument, there's allegations by the defense that the sex trafficking case was weak because there was only one victim. And Magistrate Judge Fox again detained on the basis that the victims were corroborated not only by other witnesses, but also by documentary evidence.
Anything else from the government?
Just a few additional things, Your Honor, briefly.
How many more additional things? We've got about 45 minutes. Give me a sense of what else you may need to touch upon.
I can finish just in under 5 minutes, maybe even 3.
Go ahead.
Okay, I would just touch briefly on risk of flight. The circumstances are different than when Mr. Combs flew here to sit in New York, which defense counsel has made a lot of hay about. And with respect to his offer to surrender, there are extremely valid law enforcement reasons why the government did not take him up on this offer, including the risk of evidence destruction and allowing for further obstruction. So to the extent that this surrender and travel argument has any force at all, it really only applies to risk of flight. It does not grapple with dangerousness and obstruction. Surrender has nothing to do with those two things, and the defendant really does not grapple with those two things. He doesn't talk about his ongoing danger and his ongoing obstruction. So coming to this jurisdiction and offering to surrender simply does not vitiate those concerns. The court expressed concerns with the bail package. The government has significant concerns with the bail package. Again, I'm here seeking detention, so I'm not going to get into those. But I know for the record that we do think that even the supplemented bail package does not have enough conditions that focus on obstruction. And we don't think there are conditions that can really keep the defendant from doing those type of things that he's been doing, particularly because he's been involving other people in them. You'll hear later today about how much evidence we have, and it was in the record yesterday. There's a massive amount of evidence. There's a massive amount of witness, a massive amount of electronic evidence. There's a massive amount of physical evidence that we seize. We have witnesses saying things, and these witnesses are powerfully corroborated by communications, by photographs, by videos, by contemporaneous documentary records, by text messages, and the like. And this is the evidence that we will use to prove the charges in this indictment. This is the same evidence, some of which, just a little bit of which I've highlighted today, confirms that the defendant is a danger to the community and poses a serious risk to the integrity of these proceedings through his efforts at obstruction. So, for all the reasons I've stated here and in our letter, the defendant should be detained pending trial.
Thank you. Defense counsel, again, you can stand there, you can stand at the lectern, or you can be seated, whatever you feel comfortable doing. Hello? Mr. Agafino? Mr. Agafilio? Hello? Hello? Hello?
Mimi.
Hold on, y'all.
You want me to start?
Yeah, I think she might have fell asleep.
Okay. Your Honor, I'm going to address one thing that my colleague said, and then I hope to address Your Honor's opening remarks directly. The situation that my colleague just discussed with Dawn Richard and Kalina Harper, I can shed some light on. At one point, I myself got a phone call from Kalina Harper and her lawyer. Without going too much down this rabbit hole, Kalina Harper said, "I would like to make a statement on behalf of your client." Her lawyer was on the phone saying, "I'm worried that my client, Kalina, is going to embroil herself in this big mess that has public elements to it and all that. And I'm prepared to give the lawyer's name to the government, and I'm prepared to give, to the extent that they don't have Kalina Harper's phone number, to the government, and they can follow up on this." And what I said to Ms. Harper and the lawyer is, you should do whatever you want. You should feel free if you want to make a statement, and you should feel free if you don't want to make a statement, to not make a statement.
I'm here. What line we on?
16.
I don't remember offhand what day it is. It was between the 10th and the 13th. And then at one point, I found out she made a statement.
The accosted aren't great.
I'm sorry, Judge.
You don't remember that? You don't remember what?
I don't remember the exact. It was either the 11th or the 12th of September. Then I spoke to the lawyer and Miss Harper. At the end of the conversation, it was not clear whether Miss Harper wanted to make a statement or not. Sometime later, and I think it was the next day or it could have been 2 days later, I saw in the press reporting that she made a statement. So the reason I bring this to you, Your Honor's attention, is there a lawyer in the mix? There's a lawyer in the mix? Miss Harper has a lawyer. I spoke to the lawyer. I will make the lawyer available to the government if the government wants to speak to the lawyer. So to the extent that the lawyer raises this because there's some suggestion that because Mr. Combs contacted Miss Harper, and I only would note that there were in some band for a period of time, but these contacts were around the time of the statement. She seemed to be pained about whether she wanted to make a statement. She told me she wanted to make a statement because she believed Don Richard's statement were not accurate. And she wanted to say something, yet she didn't want to get overly involved.
When she told you that, that was either September the 11th or the 12th.
I believe that's right.
Which is after the 10th, after the defendants first reached out to her.
I don't know about the defendant's contact with her. I don't know. I just know when her and her lawyer called me, it was the 11th. I'm told by the keeper of the facts that it was the 11th. So I think it was probably September the 11th, but let me address. So I wanted to point out that just because that was the last thing my colleague said,
Let me ask you, why does that matter?
because the government brought it up, and the government brought it up, I think, to suggest that somehow Mr. Combs coerced or forced or pressured Kalina Harper into. Let me take a step back because I don't think the entire context might not be clear. I don't know what role Don Richard plays in this case. I don't. She filed a civil complaint, so this is all about civil complaint. When a civil complaint hit the news, Kalina Harper, who was in the same band as Don Richards, obviously said to herself, "I was in the same band as Don Richard." I don't think I don't see any of those things.
Let me just ask you something.
Yeah, sure.
Hypothetically speaking, if your client reached out to this person on September 10th, hypothetically speaking,
Right.
and said, I want you to say this again, very hypothetically saying, let's say he said, I want you to lie about what happened. I want you to tell this story and gives that information to her on the 10th. And then on the 11th, he gets a call from her lawyer saying that she's interested in maybe something, making a statement. But he's not clear if she could make that statement. If that hypothetical situation happened, wouldn't that still be evidence of an obstructive mindset of willingness to tamper with a potential witness? I'm sure that you're going to say that the person is not necessarily a witness in this proceeding, and therefore I shouldn't consider that. But that be evidence of the mindset, that willingness to tamper with a witness or obstruct justice. Because I'm sure you would agree you don't have to coerce someone in order to obstruct justice, correct?
I agree with you. I agree with Your Honor. And I think if your hypothetical is a hypothetical, and I accept your hypothetical as that, yes, you might be right. I wouldn't necessarily know, but the reason I wanted to speak to her and Miss Jaragos remind me that we spoke on the 10th as well, and she's coming with her computer. We're going to get some accurate facts, probably more specific than I'm saying.
Your Honor, I would just want to say we just speak to her. I spoke to her, I'll say for 30 minutes on the early morning on the 11th so that she could recount her facts to us as to her. She's mentioned in the lawsuit that about 34 times that she felt that her name was also being bemished in terms of she was had a witness violence act by Mr. Cohn against the victim, victim one on count two. And so I believe the contact with that potential witness was also a potential defense witness for us to speak to, because she was mentioning violence act with the respect to the person who is now victim one of count two. So we did speak to her that night because we thought it was important in terms of our defense investigation. And that's all I have to say.
I'm sorry?
I'll let Mr. Ekalafio.
Okay, go ahead. Continue. I didn't mean to cut you off.
No, I'll let Mr. Alcaviel continue. He wasn't on that call, so I just wanted to make that representation.
That was the 11th?
That was, I think, maybe 2 o'clock in the morning on the 11th.
Okay. But after speaking to defense counsel on the 11th, what would be the reason for her and Mr. Cohn to keep in contact? I saw in the record here, defense counsel was making a statement that Mr. Cohn was reaching out to a witness to just to line witness up. If this witness has already spoken to defense counsel, what would the purpose of Mr. Cohn continue to speak to the witness after September 11th? After after your conversation with the witness, why would he need to reach out to her?
Your Honor, I can't speculate only to say that I think this witness was really upset by the fact that she kept getting publicized in many different articles and about incident that she was supposedly present. At that, she was just not. That she stated, at least to us, that she was not present for that. That's my speculation, and I don't know if.
No, I understand your honest question, and I don't know that all of these things resulted in conversation. I don't have access to the government's evidence on this point, so I don't know that all these things resulted in conversations. Obviously, she wanted to speak to Mr. Combs because her name was in the civil suit, and she didn't want the name in the civil suit. And also, and she also wanted to say, I didn't see any of these things happen. To the point that Miss Garrego's raised, in addition to being named in civil suit, she also may be important defense for conduct that may or may not be charged as part of the indictment because it relates to the person who's in count two. So this is an important defense witness. It's someone we will speak to, but I want to allay the court's larger concern and then we can come back to this because I'm hearing the court loud and clear and I have actual proposals that I think will assist in showing the court that we are taking the court's concerns very seriously. I have brought to court today in the fourth row the handsome man who lost his hair at some point is there. His name is Herman Weisberg. Herman Weisberg owns Sage Intelligence. He's a former New York police detective. He worked in the DA squad and he's had Sage Intelligence for I think about 15 years. And here's what we are proposing in addition to all of the other conditions that we have in our bail proposal. The Sage personnel from Sage Intelligence, all of whom which be former law enforcement officials, either federal law enforcement official or state law enforcement officials, will be monitoring the residence of Mr. Combs 24 hours a day. 24 hours a day, 7 days a week. Here's what this will involve. They will have at least one, probably two, Sage employees there at all times. They will basically have a full control of who enters the room and who doesn't enter. There will be a visitor's log that is kept and that we could have it shared with pretrial services every week or every day or whatever we would like to do in those regards. Mr. Combs will have access to a cell phone. Since there will be a Sage personnel on site, if we want to reach him, we can reach him that way. He won't have access to the internet. So what I'm trying to fashion in a situation where any witness intimidation, if that is the court's concern, and I see that it is, will completely nullify it. It will be virtually impossible. And Sage will monitor these things, make sure he doesn't have a cell phone, make sure that anybody who comes to the house is on the pre-approved list of visitors, will keep track of all the visitors. And we can make that list of visitors and provide it to the government, to pretrial and to the court. Sage would establish communications with local law enforcement in Florida if need to be. If there is some emergent matter, Sage would contact local law enforcement. And what we could do, Judge, and what we're willing to do is put together a protocol so that the court is absolutely satisfied and comfortable that there is quite literally no way that Mr. Combs would be able to conduct any kind of contact, have any do anything with the witness of any nature. One thing that I want to make clear in light of the government's proffer today, and I'm going to go through all of the things that I said yesterday. Your Honor, read the transcript, and I don't need to go through all of them again. Is what I believe we have very significant defenses to everything that the government has said. And we have been conducting on the defense side a very significant investigation for 6 months. And I anticipate that it's only going to increase as we get closer and closer to trial. So we will conduct the investigation, meaning the lawyers and the investigators. Obviously, Mr. Combs will have no role in that. Mr. Combs will not contact anybody who is not on the pre-approved list. We will ensure that that's the case. And if he fails to do that in any way, shape, or form, we will explain to Mr. Combs that that will be a violation of his release conditions, and he should expect to be incarcerated. And that is an obviously reason concern because getting ready for this, Mr. Combs would be in a special housing unit if he was incarcerated in the MDC. That presents tremendous challenges to us. Given the amount of electronic evidence, it's a very difficult place to be as an inmate, and it's a very difficult place to get ready for any trial, much less a trial with a tremendous amount of discovery, and this case has. So he knows the stakes. I will put something in place that would give the court and pretrial services and the government assurance that nobody will be contacted unless that person is on the approved list, pre-approved list. That will be monitored by the people at SAGE. And we are at risk of Mr. Combs being incarcerated if anybody falls down on the job. If Mr. Combs does something he's not supposed to do, if SAGE somehow misses Mr. Combs doing something he's not supposed to do, if his lawyers miss Mr. Combs doing something he's not supposed to do, we know what the consequences would be. So I'm listening to Your Honor loud and clear, and I'm going to address risk of flight in a second because the government's still moving on that theory. But I do not want to assure the court that we are prepared to put in strenuous and maybe unusual conditions to meet the court's concern when it comes to these important matters. Now, that is not to say that I agree with the government's assessment of whether these things are obstruction or not obstruction. That's an issue for another day, and I will take it up on another day. What I'm here today to do is to address Your Honor's concerns. When Your Honor came out on the bench, Your Honor shared her honor thoughts with us, and I listened loud and clear. I want to address those thoughts and I want to address those concerns directly. And through having SAGE Intelligence, their former law enforcement officer on site 24 hours a day, and will do whatever needs to be done. If we need two of them, we'll have two of them. If we need three of them, we'll have three of them. And we'll put everything in place that we need in terms of visitors coming in, visitors who are not on the list and who can't come in. That will be all done. That will all be monitored, and we will all know what's being done in that regard. So that is how I intend to deal with that. Mr. Combs, like I said, would not have a cell phone. He would not have any ability to use the internet. That would, I think, come a long way to giving the court greater comfort in this regard. I do want to address another issue because I don't believe that the actions that Mr. Combs has taken in regard to surrendering his passport and coming to New York for only in regard to flight risks, I disagree with my colleagues' assessment in that regard. Because I think what it shows is that he is deeply respectful of the court's authority. He is willing to show that he is responsible, that he can follow these directions, and that he is mindful and has been mindful, and this is important. He is mindful and has been mindful for a very long time that this is a significant investigation and that the charges could be significant. Significant because they're true, but significant, not significant because they're true, but significant because they're weighty charges. And with the sex trafficking count at the minimum, it has a rebuttable presumption of detention. So I want to put these in somewhat of a different light. And I won't belabor it because I know Your Honor read this already. When we told the government on April the 1st, all those months ago, that we had Mr. Combs' passport, we were giving the government an assurance. He was not going to travel internationally, which he hasn't, and the government would know where he is. Mr. Combs was willing to do that because he understood that this was a significant investigation. Now, what I want to point out in this regard is this. Back on April the 1st, when we sent the email to the government and said that we have Mr. Combs' passport, we specifically went through the charges that we believe they were looking into. And we specifically mentioned racketeering conspiracy. We specifically mentioned sex trafficking. We specifically mentioned violation of the Mann Act. We mentioned all three counts that ended up being an indictment. So back on April 1st, we knew exactly the nature of this investigation, and it turns out we were right. But the significance isn't that we're right. The significance is that we knew it was substantial. And even in the face of the substantial investigation, Mr. Combs surrendered his passport. Now, but that wasn't all.
I'm sorry, I was muted. Just to be clear, you're saying you're including your client, Mr. Cohn, in that he was aware that at least by April 1st?
100%. Just to make it clear, Mr. Jaragos and I flew to Florida. We sat with Mr. Combs in his house in Florida, and we said, "You are being investigated by the Southern District of New York for a number of serious charges. Let me tell you what they are. It's racketeering conspiracy, it's sex trafficking, it's obstruction of justice, it's prostitution, Mann Act type prostitution." I mean, we were right because we knew what they were looking into. We also knew it because there was a search warrant, and the search warrant had crimes in it. So he knew. He knew on April 1st exactly what they were looking into. Now the government in their letter to Your Honor today somehow makes an argument that this is like defense lawyer. I think they all call it defense lawyer theater, but it's not theater at all. It's actually a person showing tremendous respect for the process and showing the court that he can be trusted because what we went also on to do is we took the passports of 5 of his family members. And the family members of his family and friends are here today in the second row. They love him, they support him, and many of them gave us their passport over the last several months. We also made efforts to sell his plane, which is in the process. We have a letter of intent to sell the plane because I was concerned that if he had access to that airplane, that would give Your Honor concern. That would give the government concern. I credit the government for not raising it as a concern, and I think it's not a concern because we're selling it. But the significant thing is we had the foresight to try to sell it. Apparently, selling a plane is not an easy thing to do. We've had 3 different buyers who didn't work out. We're on I think the 4th buyer, but hopefully we'll actually sell it this time. In the meantime, we will make sure that Mr. Combs is not. So let me just back up for a second. Because he is not using the plane, no plan on using the plane anytime in the near future. It gets chartered because the plane has to keep flying or the plane apparently starts to fall apart. So it's chartered and it's being chartered. It's being chartered by other people in sort of a public way.
Can you just get to the point where you said that it doesn't relate simply to the risk of flight?
Yeah.
Can you tell me what this relates to otherwise?
It shows respect for the court. It shows that he is trustworthy. It shows that he is showing that this is a serious process to him. Your Honor must have seen defendants who thumb their nose at the court and say, "Come find me. I'm not going to show the court the due respect that it deserves. I'm not going to do the things the court show. I'm not going to do the things to show the court that I'm trustworthy." Some defendants flee outright. In some cases, they are distinguishable, and your honors read like Maxwell and Epstein.
How does that relate to the dangerousness generally or danger of obstruction? Because it seems to me that what you're saying relates to danger of obstruction, but not in a good way for you. If if he's aware of this since April 1st, 2024, then again, why is he contacting witnesses in June and July of 2024?
So I have an answer. A witness contacted him. I think I know what you're talking about. And a person contacted my client on Signal, so it does show up. And I wanted to talk to him, and he spoke to her. And the witness, I'll tell you exactly what happened. And the witness told him, I am a grand jury witness. He told us that. Miss Jaragos and I, and we said, don't talk to her anymore. And he didn't talk to her anymore. And that was that. So she contacted him. If it's the thing that I'm thinking about, and I think I'm right. So that is not him reaching out to a witness. He did not reach out to grand jury witnesses. I dispute that wholeheartedly. He didn't do it, and he wouldn't do it. And he wouldn't do it because he has a sense not to do it. And he wouldn't do it because he wouldn't let him do it. Because we wouldn't let him do it, you know? So as much as we
Okay. Let's get back to again this point that you're making. This all seems to be that this is just related. This is again cabinet for risk of flight. So tell me again why surrendering of the passports and everything that has something to do with danger. You're saying it shows respect to the court, respect for the process proceedings that seems quietly seems risk of flight.
because I think part of defendants who are dangerous. Once the court process starts, are people who have disregard for the court. It's contemptuous of the court. They are doing things, they're engaging in conduct that they know is contemptuous to court. And everything that Mr. Combs has done has shown he is not, and has never been contemptuous to the court. In fact, his whole life has been the exact opposite. And it's important that I bring this up to your honor because I think it's a serious consideration. It's not on his rap sheet because he was acquitted, but it's well known that between 1999 and 2001, he had a very significant criminal case in Manhattan. He went to trial and he was acquitted. And during that over 1 year period, he went to court every time he was supposed to. During that 1 year period, there were no issues with the witness. There were no issues with danger. And he abided by the process. He showed respect for the court. He came to court every day. He went to trial, and a jury of 12 New Yorkers found him not guilty. So, this is someone who actually has shown that when the chips are down, when the pressure is on, he doesn't do anything that he is not supposed to do. He shows up on time. He shows up every day. He didn't do anything with witnesses. He didn't do anything dangerous. And that is track record. That happened. That's not just his lawyer making an argument. That's the truth. And that's in the record. That happened. There's no issues with him for that over 1 year period. And he went to trial and was acquitted. And he's going to show the exact same respect for this court. So the reason it relates to danger, and the reason it relates to government concerns of witness intimidation is because he hears the court loud and clear. There's a case now, and he's going to do everything right from this point forward. And I'm not asking your honor just to trust him. I'm asking your honor to trust him. I am, but not that alone. I'm saying that if we put in place the different measures that I have in the bail package and the letter that we submitted to the court along with sage intelligence, which we didn't name them. So I understand why the government thought that we were going to use the same security services that's been in place all this time, but that never was the plan. The plan was always to use a company like Sage Intelligence, and that's the plan now. That in addition to the fact that he's shown that he is trustworthy, and I believe he has, because I believe the incidents that the courts, that the government's talking about, do not amount to witness intimidation in the slightest. That we have in place a foolproof system that would give the court what it needs. He is not going to contact anybody. He is not going to reach out to anyone. And he is not going to let his lawyers do the defense investigations as we should.
But tell me more about this allegedly full foolproof system that you're proposing. Under the system, would Mr. Combs still have employees?
He will have employees. He has employees. He has, people who manage his finances. They're not necessarily in the same house. They're located in California, but he does have employees.
Would it be necessary for him to speak to these employees or have someone on his behalf speak with these employees?
We could work that out. There's going to have to be some way of communicating with the employees, some form of fashion of doing that. I mean,
And under your proposal, would Mr. Combs be able to leave the residence?
no, I don't anticipate that he will.
What would your proposal be? The security company, you said that they be there.
Yes.
What does there mean?
So there is his home in Florida is the one that we're looking into to secure the bond. It is in Miami. He would live there, and the security personnel would live there as well. I mean, they will probably do it in shifts. I don't exactly know how, but they'll probably do it in 8-hour shifts and rotate in and out. But there will be,
But the proposal is that they would just be in the house, not sitting there looking at him the whole time, correct?
I don't know that they would need to sit there and look at him. I think what we could do is we could put cameras. We could put cameras. We could put cameras at the entrances that are filming 24 hours a day. And that will be in the house and aware of the goings on. If there were requirements that he don't have a cell phone, we could find ways of doing spot checks to make sure that he's not on the cell phone. If the requirement is that he doesn't use the internet, we can do spot checks that he doesn't use the internet. But we can make it as secure as we need to make it. And let me just add, there are already, and the government knows this because I think they took a lot of the footage back on March 25th. There are cameras in different parts of the home. So we would need to do is kind of keep up with those cameras rolling. I'm happy to share the footage with anybody who wants it. But what we would do is we will monitor those cameras in addition to physically monitoring the situation with the officers on site.
Who would be living in the house with him, the home with him?
1 second. I think we can arrange things so he's the only one living there, and that Sage will be working there doing security, and he be the only one actually residing at the house.
But there would be visits from family members and employees and friends and like, correct?
Assuming that those people are, we will put together a list. We will share it with everybody who wants to see it, and those will be the people who visit. And nobody else will visit because Sage won't let them in.
Go ahead. This is there anything else you want to address the violence and the danger more generally?
Sure. Yes, Judge.
I know you made some statements before regarding 2016's incident.
Yes, Judge.
Again, that video is quite disturbing, and it was 8 years ago. But he's still 46, 47 years old at the time. Is that taking place?
He was.
And this was after his acquittal on the state court charges?
It was. So let me shed some light. Your Honor asked a question, and I think there's a question to it, an answer to it. In the weeks and months after the video, Mr. Combs realized he has a problem with drug addiction, and he has a problem with anger, and he went into a rehab program for a period of time. I don't want to get too much into this, but it's significant. The person, the woman in the video, also went into rehab around that time. The point is, this was a 10-year relationship that was very loving at times. These people loved each other. And I don't think there was any other view of the relationship than that, because they're just, the written messages are, it's heartbreaking. It's some sort of heartbreaking relationship in many ways, because they really did love each other. And I think what the government is doing, and I'm not saying this is in a bad way, but I think the dynamic of the case that I object to most respectfully is this. The sex and the violence were totally separate and motivated by totally different things. The way this couple chose to be intimate was the way that is. They will bring a third party into their intimacy. That was their thing. This is how these two adults choose to be intimate. And the written communications judge are overwhelming. That this is so, not only that it was consent, it was assault thereafter. It was assault after, special part of their relationship. And in some ways,
What does this have to do with him punching her, throwing a vase at her, kicking her? What's love got to do with that?
it's a good question. And the answer is, it has nothing to do with it, because that's not what motivated that stuff. The intimacy is over here. Okay? All of the problems are not related to intimacy. The problems are related to jealousy and infidelity. That is where the problems come. You have jealousy from infidelity, you have arguments, you have fights, you have things like you saw in the video because of jealousy due to infidelity, in both directions, in both. And the part of both participants, Mr. Combs and this other person, is mutual. And the violence is from that 100%. And the written communications make that clear.
Let me just make sure I understand your point on this.
Yes, Your Honor.
What is your point on this? You're saying that the reason because of jealousy, that's the reason because they had an argument, and that's the reason that he punched her, threw her a vase at her, and kicked her.
I'm not saying it's not sex trafficking. The government is linking the two. And in the linkage, they find sex trafficking.
The government's also talking more generally about the violence against women, violence against those particular women who the government claims was sex trafficked. And let me ask you this thing. If you're talking about to the extent that you claim that this sort of behavior was that inviting another person into a relationship was somehow consensual, if that person is a sex worker or a prostitute and travel across state line, isn't that a problem regarding count 3 in the indictment?
My son is making noise. I'm sorry. It may or may not be. I have spoken to the people from this agency, and what they uniformly say is, we are not paid to have sex. We are not paid for our time. And if we meet somebody and it goes into that direction, everybody wants to do this, and there is sexual contact, then it sometimes happens. And listen, at the end of the day, the one-time governor of New York was investigated by the Southern District of New York because he was sleeping with and our prostitutes while he was the governor. And they didn't prosecute him. They are prosecuting Mr. Combs for the exact same conduct. So, yes, let me assume for a second. Let me assume for a second for your honest question is right. Okay, that is, oh my gosh. Please hurry up. 1 second, Miss Sylvia.
All right, let's have intermission for y'all. Hold on a second. We're gonna do intermission while her son.
Sylvia in that courtroom grind. All day long she's making time. Notes in hand, she's got the plan. Comes home late, shines like a star. Yeah, she's here to break it down. Justice found without a frown. In our chat with hearts so true, Sylvia's magic comes right through. Feel it, baby, feel the light. Soulful notes on the inside. Sylvia's truth makes us sway. All night long we groove and play. She's the queen with a golden touch. In her words we trust so much. Courtroom battles fade away. She brings the light in the day. Slide it slyly, can't deny. Sylvia knows just how to fly. All I want, she melts away, bringing soul to every day. Feel it, baby, feel the glide. Soulful notes on the inside. Sylvia's truth makes us sway. All night long we groove and play. Feel it, baby, feel the glide. Soulful notes on the inside. Sylvia's truth makes us sway. All night long we groove and play. Ooh,
All right, guys, we're back.
It's not sex trafficking. Trafficking. That's my point. The reason we're really all here and
That would be a crime. That would be a federal offense.
no, I don't think that's the truth because I don't know that. If you read the Man Act, the consumer of the intimacy is within the purview of the Man Act. My read of the Man Act is that it's about the business of sex. There is no argument that Mr. Combs was involved in the business of sex. That's not an argument.
Let's get back to the video and a physical beating.
Yes.
Why isn't that relevant in the consideration as to danger to the community more generally and the act of violence against women and what the government has alleged here?
Judge, I think it's relevant. I think it is relevant. I haven't said that it wasn't. I'm saying it's not a part of sex trafficking. That's my theory. That is not a part of sex trafficking. It's relevant. Is it relevant? Your Honor, going to look at the video the way everybody look at the video, the way Mr. Combs looked at the video. Mr. Combs issued an apology after the video, and I'm not going to undo his apology. It's hard. It's a hard video to watch. It's an upsetting video to watch. It was upsetting video to watch for everyone. but that doesn't mean he should be incarcerated. It's 8.5 years ago. He went into rehab since then. He has done tremendous things to try to change a person since then, and he's not the same person he was then. He was in a relationship that was toxic, that was a toxic relationship. And probably the best single thing, both for him and the woman involved, is that they broke up and they both went their separate ways 7 years ago at this point, 6 years ago. 6 years ago, they broke up at this point, and sometimes that happens in life. You know, Mr. Combs has the unfortunate reality that one of the most things he's never done was on videotape. I'm not glad that I'm glad that didn't happen to me. None of us should be apart. None of us should be that unlucky. But one of the worst things he ever did happen to be on videotape, and it will one day be played at his federal trial. We will deal with it when it is. So I'm not asking Your Honor to ignore it. I'm not ignoring it, but I don't think it's disposi- dispos- dispositive. And I don't think in and of itself it means that he should be detained pre-trial. We have defenses to charge. That's the point. We have defenses to the charge, real defenses. This is going to be a trial one day, 100%. He's not going to plead guilty to racketeering and sex trafficking and those things. He's not. So this is going to be a trial. And I'm asking you, because it's so critically important, we have proffered, Your Honor, a very substantial bail package. And him coming to New York, Judge, I think also is not just important in terms of risk of flight. I think it's important for every aspect of what we consider when we think about bail. I mean, this is a man. We had a meeting with the government. Miss Jaragos and I met with my colleague to my right here. I think it was September the 3rd. It was a day after Labor Day, the Tuesday after Labor Day. And Miss Jaragos and I left that meeting. And I realized they were going to return an indictment soon. I didn't know if soon was a week. I didn't know if soon was a month. I didn't know if soon was 3 months. I got on the phone with Mr. Combs the next day and I said, "You should consider coming to New York because I think they're going to charge you soon." He got on a plane on September the 5th and came to New York. And he came to New York to turn himself in. He came to New York to surrender. And I told my colleagues, he's here. He wants to surrender. Just give him a time and he'll be there. I understand that they don't have to do it, and they didn't do it. They told me they would get back to me, and then he got arrested. And that's okay. That's okay. But the fact he got on an airplane to come to New York when so many defendants, judge, get on the airplane or a bus or a train or whatever and run as far away from the place of danger as possible. The fact that he did the exact opposite is weighty consideration of him in general. And so when I say to the court that I want the court to trust him, he has earned the court's trust. And even if the court doesn't fully trust him, trust the package as a whole that I'm proposing with a $50 million bond, which is a tremendous bond secured by $50 million in equity with the cosigners that we've proposed, with the passport surrender that we've proposed, including his own passport, with electronics monitoring. He stays in the house. Sage Intelligence supervises the house. We have a list of permitted visitors. He doesn't have a cell phone. He doesn't have any internet access. And I believe that we'll do two very important things. It would give the court comfort that he's not a flight risk due to the conditions. He's not a danger. He's not a danger of any witness obstruction with these conditions. And it allows him to prepare for his trial in a fair way. And everything that we have been doing, we have known this was coming. If he was going to run, if he was going to do something reckless and stupid, he would have done it in March, and he didn't. Instead, he gave us his passport, and we told the government we had it. This is someone who has worked hard his whole life. We have gotten too much into his personal characteristics, but I think it's actually somewhat important. He has, first of all, he has one misdemeanor conviction from 29 years ago. That's it. He's 53 years old. One misdemeanor conviction from 29 years ago. He was an actual altar boy growing up. He was a very religious man.
How far back are you going now?
The man has, I'm going back and I'm talking about him as a person because it's all one continuum.
Okay.
He watches a sermon every day. He's religious. He comes from a religious family. His father, unfortunately, was killed when he was 2 years old. He was raised by his mother, who did a wonderful job with him. And he has worked hard and he has earned everything that he's ever gotten in his life. And the one thing that I'm asking your honor for is to see that he has done everything to earn the court's trust. He has done a great deal to earn the court's trust. And I'm submitting that this very, very substantial package, both what is written in the letters, supplemented by what I said today, and supplemented still further by Sage Intelligence being on site. And we can have any protocol that your honor sees fit. We're certainly suggest one, but if your honor wants something more or different, we can do whatever your honor thinks is necessary. That that in combination, that substantial package means that when that he should be released to work on this case, to meet with his lawyers. If we need to speak with him by flying to Florida, we'll do that. He'll stay in his house in Florida and he'll do nothing but prepare for his trial. So I'm asking you to release him on these very, very strenuous conditions, Judge. Thank you.
Thank you. All right. I've heard from the parties. I've reviewed everything. I find that the government have proven that the defendant is a danger regarding obstruction of justice and witness tampering by clear and convincing evidence. I also find that the government have proven that the defendant is a danger to the safety of others in the community, more generally by clear and convincing evidence. I need to I need not reach this resource. I'm sorry. I need not reach the issue of risk of flight. Again, I find that the government has carried its burden of persuasion by clear and convincing evidence on dangerousness both for obstruction and witness tampering, as well as danger more generally, even if the defendant has rebutted the presumption by coming forward with their own burden of production. Gathering the bail package that has been proposed by defense counsel in terms of risk of flight, I think is insufficient. In terms of overcoming the government's had in terms of overcoming what the government has proven, again, I say it this way. Again, the government has proven by clear and convincing evidence that there is no condition or combination of condition that will reasonably assure that the safety of person in the community, as well as that he will not obstruct justice or tamper with witnesses. There are issues also with what the defense has suggested in terms of sage intelligence. Certainly, the defendant will still have access to employees and other individuals. And given that what the government has proffered, he could certainly obstruct justice and intimidate witnesses through those folks, through even coded messages if necessary. So I'm denying bail and I'm granting the government's motion. We are scheduled to have an initial conference on the 24th. Since we're here, I don't know if we need to do that. Perhaps we can just find out how counsel wishes to proceed. I know that Mr. Combs was already arraigned on the indictment. So how do the counsel wish to proceed? Let me hear from the government first.
Thank you, Your Honor. Happy to give the court an overview of the discovery in the case and also the government's proposed schedule. So first, I think it's important to note that Your Honor probably has seen this from the record so far, but there is going to be a huge amount of discovery in this case. It's going to consist of dozens of terabytes of data. Then I want to cover some of those categories of the Rule 16 discovery that will be disclosing to the defense. First, it will include grand jury subpoena returns. For some context as to the volume of those returns, we have served over 300 grand jury subpoenas in the case and gotten returns from over 100 individuals and entities, including phone companies, tech companies, social media companies, hotels, airlines, some companies related to Mr. Combs himself. Second, the Rule 16 discovery will also include search warrants. We've obtained over 20 search warrants in this case, including warrants for electronic devices and iCloud accounts, including warrants for his hysterical and prospective cell phone information, and for a variety of persons, as well as for Mr. Combs' residence. Third, the discovery will include photographs of physical evidence, including evidence that was collected from his residence in March 2024, as well as from his hotel room a few days ago, which includes freak-off supplies, narcotics, firearms, and ammunition. The discovery will also include a variety of law enforcement reports and records, including from local law enforcement. And finally, there are a large number of electronic devices in this case. Specifically, over the course of the investigation, including in the past few days, the government has been collecting electronic devices and in total has seized over 100 phones, laptops, tablets, and iCloud accounts, as well as over 30 other kinds of devices. And here, I'm talking about things like hard drives, flash drives, cameras, DVRs. These devices are often large, sometimes hundreds of gigabytes, sometimes terabytes, especially in relation to the iCloud accounts. Already, the government has extracted approximately half of those phones, laptops, and tablets, and iCloud accounts. And these devices are in the process of a privileged review, varying stages of it, and they will then be reviewed for identified data and review, and we will produce that identified data on a rolling basis to defense counsel as it becomes available. So although this is a large amount of discovery, we have a plan for producing it to defense counsel. First, before producing any discovery, as Your Honor might anticipate, we will need a signed protective order, given that the discovery will contain sensitive victim and witness information, and we have, as we've discussed, real concerns about witness tampering, as well as with the sensitivity of the victim information and statements that have been given to the media so far. So we will start engaging in those discussions with defense counsel today about negotiating the protective order, and we'll let Your Honor know if there are any issues with that process. Second, soon after getting the protective order signed, we plan to produce the affidavits related to the search warrants that we've obtained in this case. As I said, there are over 20 of them. Many of them have lengthy affidavits which lay out large portions of the case and will assist the defense in assessing whether there are motions that we would like to make. Third, within approximately 30 days of having a protective order, the government will intend to make a large production of discovery to the defense consisting of a variety of things, including grand jury subpoena returns. But importantly, we are prepared to produce many of Mr. Combs' own devices and accounts. We have approximately 35 full extractions ready to produce to the defense. We anticipate that the copying of those devices, given their size, will take some time, but we will engage in that process as soon as we can. And finally, our plan would be, after this initial large production, to continue to make productions on a rolling basis. And I just want to note for the court that our investigation in this case is very much ongoing, and we will
to sleep, Big Moose.
continue to produce the information that is in our possession. And as we get more related to the new investigation, we will also review that in accordance with our discovery obligations to produce to the defense. We think it makes sense, in order to give defense counsel sufficient time to review this discovery, to have a status conference in approximately 90 days.
Okay. Defense counsel, let me hear from you.
Yes, Your Honor. I am, without speaking to Mr. Combs in greater detail, in light of the fact that he's going to be in the SHU of MDC, I'm not in place where I'm prepared to consent to a speedy trial. I'm not saying that I won't be in the future, but this is a serious conversation we have to have. And the fact that he's going to be incarcerated is a significant factor. So I don't know that I can consent to a 90-day adjournment for a status conference. I think we would want to reserve the right of moving much quicker than that. The government arrested him. The government wants him detained, and we're going to have to do everything possible to move this along. So where I am today is I'd like to take some time to speak with him, and more than just a few minutes here. We need to go through this in real detail. I also need to see what's going to be possible in the SHU. And I don't know what I exactly know that now in terms of what computer facilities are going to be possible. And so at this point, I'm not prepared to waive speedy trial.
So what do you want to do at this point? Do you want to set a trial date? Do you want to? Because I would, well, I don't know. Do you want time to review the discovery that's going to be produced? Do you want to come back in 45 days? Or do you want me to set a trial date? I can set a trial date if you want me to set a trial date.
I understand.
Whenever you want it. And if I can't try it, I'll find a colleague who can, if you want to set a date trial.
Can I just talk to the government for a second? I just have a question.
Yes.
I have a proposal. Would Your Honor be amenable to the status conference in somewhere between 14 and 20 days? And in the interim, what I think we'll have a better handle on is how Mr. Combs will be able to look at the discovery and what discovery will be available when and what from technical perspective he'll be able to look at and with what level of difficulty. So my ask of the court is that we have a shorter turnaround time for a status conference, and whatever's good for the court in that general period of time of 2 to 3 weeks.
Okay. We can do that. What's your position on speedy trial time between now and 2 to 3 weeks period?
Without a much more in-depth conversation with my client, I'm not prepared to waive it.
Okay. What's the government's position on whether or not I should exclude? Well, let's get the date first of all. How about October 9th? Are counsels available then?
1 second, Judge.
Let me say 2 o'clock.
That's fine, Judge. Thank you.
Does that work for the government?
Yes, Your Honor.
Okay, let's set this down for October 9th at 2 o'clock. I know the defendant says you don't want to waive speedy trial time. Fine. What is the government's position on whether or not time should be excluded, and what's the position on that?
Your Honor, the government would move to exclude time under the Speedy Trial Act. The ends of justice outweighs the interest of the public and the defendant in the speedy trial here, given the complexity of this case, given the need for the government to produce discovery to the defendant, and for the defendant and his counsel to begin to review that discovery.
All right. So, defense counsel, I understand your position. You don't want to waive speedy trial time. I get that. But would you be prepared to try this case in October 9th?
No, no, I'm not saying that I am. What I'm saying is I need more information to come to court with an intelligent position on this. And the things that we don't know is what his ability to look at the stuff would be where he is. I don't know where he will be in the MDC. Where they designate him is significant to that. I think the government is, it might help in the process of trying to make sure that he gets what he needs. And I think by October the 9th, we'll have a better idea of what they can produce and when. So, no, I'm not looking to try the case on October the 9th. That would be irresponsible. I'm not asking to do that. But what I'm asking to do is the government is going to move with all, urgency to get me everything. And then October the 9th, I think we'll have our arms around the situation a little bit better.
Okay, I will exclude time under the Speedy Trial Act from today's date until October 9th so the defense counsel can get the opportunity to consult with his client, get an opportunity to start reviewing the discovery, gets an opportunity to decide how they want to proceed with this case, and also to be better prepared for trial in this case. I find that the interest of Mr. Cone and the interests of justice support exclusion of time under the Speedy Trial Act from today's date until October 9th. I further find that the interests of Mr. Cone and the interests of justice outweigh the public interest in a speedy trial. I will enter an order to that effect. Let me just share something with counsel. We receive a couple of calls in chambers today from people who claim to have information related to the prosecution of this case. We do not engage with those individuals other than my staff instruct them to reach out to the U.S. Attorney's Office. I just want to let counsel know that. Another thing is that in their most recent submission, the government made allusion to local criminal rule 23.1. Is there anything that anybody want me to do about that? Counsel for the government? Again, that relates to statement allegedly made by defense counsel on some news channel recently.
We're not asking the council, we're not asking the court to do anything right now, Your Honor. We just wanted to put a marker down that we thought some of the comments got a little bit close to the line under the local rule, particularly with the respect to issues regarding the victim and potentially inadmissible evidence. So we just wanted to flag that for the court.
Okay. Anything else from defense counsel on that?
I'm not sure that this is something that the court.
They're not asking me to do anything. You don't have anything to say? Say anything?
No, it's not about that.
Go ahead.
I believe, and I know that courts sometimes do this in terms of sentencing. I've never actually asked court to do it on a pre-sentencing posture. I think Essex County would be preferable to the MDC. And I know that they do house certain defendants, even in Southern District and the Eastern District cases in Essex County. I don't know what Your Honor can do to help in that regard. I've never made this request of court at a pretrial setting, but if Your Honor would say you don't have any objection to it, if that was consistent with the protocols that existed, that might even be helpful. And then I'll take the weight on myself to try to make that happen if I can. So any little thing could help me.
Okay. Government, what's your view on this?
I don't have the cite off the top of my head, but I know that in the regulations that's the designation authority is entirely given to the BOP. I think this gets a little complicated, and I don't know that there's anything that the court can do to put the thumb on the scale of where he's placed. I think that's ultimately a decision of the Bureau of Prisons.
My sense is that what defense counsel is asking is it's a kind to at sentencing, even though the court has no authority to dictate whether someone is held, where someone is held. Basically, a kind is the court making the recommendation that someone be housed at a particular facility. Again, I'm not aware of that being done pre-trial. So perhaps what we should do is have counsel file a joint status report regarding this issue, regarding what, if anything, the court can do in that regard. Certainly, defense counsel can look into this on your own and let's get that by Monday, September 23rd. Does that work for the defense?
Yes, Your Honor. Thank you.
Does that work for the government?
It does, Your Honor.
That will be a joint submission. Is there anything else today from the government?
No, Your Honor. Thank you.
Is there anything else today from the defense?
No, thank you.
Let me I just say this. We have status conference date for October the 9th, and I'll be around, and we can certainly do that. I know that being placed in MDC will be difficult, and often when prisoners are taken to court, they're often woken up at 3 a.m. or 4 a.m., 4 in the morning, and taken to court. If counsel have discussed matters with themselves and come to some agreement as to how we should move forward, I will not object to counsel submitting a joint report a couple of days ahead of time, because there is no reason to have court appearance just to simply adjourn it for another day. Anything from the government on that?
Understood, Your Honor. We'll speak with counsel and see if we can reach any resolutions prior to October 9th.
Anything from the defense on that?
I understand the court's position.
All right, we're adjourned. Thank you. Woo! We finished, y'all. Woo! Lord have mercy. Oh, wonderful job, young ladies. Wonderful job. I thank you. I appreciate it. All right, everybody. We are thankful that the night is over. We did this in less than 2 hours, y'all. Less than 2 hours. Shout out to my readers. We did this with 3 people. So this was a job. Really 5 people. All right. Good night, everybody.
Good night.
Well, no court tomorrow because I'll be traveling. No court tomorrow. No court Monday. No court Tuesday. No court. Tuesday will be court at same time, 8:00 p.m.
Yes,
All right. All right, ladies. And we'll be doing I think the 24th. I think that's the next court date, or October 9th. He said, right? October 9th probably a date that we have.
Okay.
All right, my darlings. Good night, everybody. Thank everybody for being here. Don't forget to hit the like button, share, subscribe, and put the notification on, because we will be continuously reading the transcript. Also, those who want to donate to the transcript. And I know there have been people making all kinds of accusation lies, but the facts are the facts. You don't get any transcript for free, y'all. It's no freebie. And I know folks are trying to say, oh, it costs them. I did show you the email. I showed you the website for the court reporter. You can call the court reporter yourself to find out. And if I don't get enough donation, we just won't be doing it, okay? But I would really like to do what we did with R. Kelly's case. So you guys desire to donate, please do so. And don't listen to those people that's telling lies, because they're trying to sabotage you guys from getting the information. They're trying to hinder us from doing what we're supposed to be doing, which is getting the information out to the people so you can hear it yourself, okay? And if you want to, that's fine. If not, we can move on and not get it, okay? All right. You have a great night, people. Thank you again, ladies. You guys rock. Y'all the bomb diggity. Good night,
No
everybody.
problem. Good night.
Good
Bye.
night.
Good night.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign and joys we'll both gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign and joy's what we'll gain. We're a family, not just a show. Every click and comment